Good afternoon, everyone, and thank you for joining us today. I would like to welcome you all to the Center for Public Legal Education Alberta's webinar series on Your Legal Questions Answered. Today's webinar will be on understanding prenuptial and cohabitation agreements. My name is Jagat, and I am a research student at the Center for Public Legal Education Alberta. I will also be the facilitator for today's session. Matt, who is CPLEA's communication coordinator, is also in the meeting. So throughout the presentation, he will be monitoring and putting some helpful resources in the chat, so keep an eye out for that. You will also see two additional faces on the screen who are our panelists, and I will introduce them shortly. Before we move on, the Centre for Public Legal Education Alberta respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant communities. We do need to start this presentation with another disclaimer. This presentation contains legal information and is not intended to be legal advice. We would also like to extend a gracious thank you to our funders, including the Alberta Law Foundation, as well as the Department of Justice Canada. And then also a few housekeeping items before we dive in. We are recording today's presentation. It will be available on our YouTube channel to watch on demand in about a week. We will also have a question and answer period at the end. So you can type your questions in the question and answer box throughout the presentation, but we will address them only during the question period. As well, when you exit today's webinar, you will be prompted to complete a short survey about the presentation. We kindly ask that you take a minute to do so to share how we did today and what other topics you'd like to learn about. So who are we? The Centre for Public Legal Education of Alberta, also known as CPLEA for short, is a nonprofit organization that serves all of Alberta. So we provide legal information, education in various formats, including web, print, resources, videos, webinars, a blog, and more. So our goal at CPLEA is short. We want to make the law understandable for all Albertans. Beyond sharing with Albertans what the law says, we aim to empower them to use the law in their lives. So to learn more, you can visit www.cplea.ca to get started. And now to introduce our panelists. So we are pleased to welcome the following folks to our panel. So Tracy Brown is an Edmonton family lawyer, child counsel, collaborative lawyer, mediator, and managing lawyer of Brown Law Group, which is a 6-lawyer family law firm. She is passionate about access to justice strategies to reform family law and enhanced ethical obligations for family lawyers to do no harm to children and family. She also loves teaching and mentoring and also spends a lot of her time volunteering. When there is a spare moment, she is obsessed with true crime and watching criminal trials on YouTube. So thank you, Tracy, for joining us today. And then our second panelist is Mathieu Maillet. Mathieu passed the bar in 2020 and is currently practicing at BARR LLP. His focus is on divorce and family law, with a particular specialization in separation that involves businesses, farms, or complex investments. Before law, Mathieu obtained a degree from the University of Alberta in finance and economics. He is born and raised in Edmonton and likes to spend his free time trying new foods, being physically active, and traveling whenever he can. So thank you, Mathieu, also for joining us today. And since today's presentation will be a panel discussion, we will dive straight into the questions. So to kind of set up a little bit of background context, our first question is, what is a prenuptial agreement? Tracy, if you want to take this one first.
Okay, so hi, everybody. Welcome. I wanted to just sort of say at the start that there's lots of different agreements that we talk about in relation to families, people living together, both before they live together or marry and when they separate. And so today the focus is on prenuptial agreements and cohabitation agreements. And the prenup, as sometimes we hear it called for short, is really just a contract. It's a contract between two people. It falls under that broad category of what we often refer to as domestic contracts, or contracts in the context of family law. And sometimes it's referred to as a marriage contract, because the idea of prenuptial is pre-marriage. That's the sort of thinking of the word prenuptial. So it's in contemplation of marriage, but it typically happens before a marriage, and sometimes would occur before a cohabitation. And by cohabitation, I mean, often people don't legally marry anymore, but there are still some legal distinctions between people who live together and people who legally marry. So it's important to keep that in mind. So the long and short of it is a prenuptial agreement is a contract. It's a marriage contract or a contract in contemplation of a possible future marriage. It's a contract that typically two people, just as an aside, the law isn't really keeping up with some of the new types of families that involve more than two people, and that can get complicated, but it's usually contemplated as a contract between two people, although certainly I'm sure it's possible to include others. And it's meant to set out what the expectations are with respect to rights and obligations and entitlements that are anticipated, because it's got a future looking perspective. It's not at a separation when you sort of are dealing with dividing up things and assets and money and obligations. So it's about expectations between people and trying to provide a framework to avoid conflict if in the future things don't work out. So typically it would be a type of agreement that would come up when there are assets, like say two people are going to live together, potentially marry, and one or both of them have assets that they bring from prior marriages, or they're wanting to protect inheritances for children, or they're wanting to have clarity around what might happen with property, the money, if the relationship doesn't work out. Typically, that's when you get a prenuptial agreement. And I'll shut up now too. We have lots of questions, but just to say, we often, let's be fair, it usually comes up when there's an imbalance where you've got two people and one person has much more in the pot than someone else. That's the typical scenario where you talk about and people start thinking about a marriage contract or a prenuptial agreement.
Perfect. Thank you so much, Tracy. Matthew, do you have anything to add to that?
Tracy hit most of the points there. I'll try to just bring it down to a little bit of a Coles Note version. So Tracy absolutely is accurate when she says it's a contract intended to be entered before marriage. Prenup, with its title, specifically references marriage. And for these sorts of contracts to be enforceable, they actually have to indicate in it that it is being signed in contemplation of marriage. What a prenuptial agreement is going to do, as Tracy said, is going to cover some of the entitlements that individuals gain upon being married. The two primary ones you're going to see in there include property and spousal support. Okay. And with property, what the prenup is going to aim to do is determine how certain property is going to be divided if the marriage is to fall apart. And with support, it's going to aim to determine, limit, or in some way change or alter various support entitlements that someone might have if the marriage, again, fell apart. But Tracy hit about all the points there, so that's all I really want to add.
Okay, perfect. Thank you both. And then that leads to the next question, which is probably important to kind of create that distinction between what is a cohabitation agreement then, and how does that differ from a prenuptial agreement? So Matthew, if you would like to start.
Yeah, absolutely. So I should be clear that there is no specific definition given to us by our Alberta legislature about what is a cohabitation or what is a prenup. The language in the law doesn't specifically use cohabitation agreement. It just says agreements. Now, a cohabitation agreement, different than a prenup, is any agreement entered by a couple who are looking to live together, who want to protect their various entitlements that they may gain while living together. The legal context we use them in is specifically with reference to adult interdependent partners. In Alberta, when I see adult independent partners, what that means, if you've heard language elsewhere, is common law. Common law is not a term we use in Alberta, but adult partners is. So when adult interdependent partners, it's a mouthful. Apes start living together. They have the option of signing cohabitation agreements to determine how their property or support entitlements are going to be determined if they were to separate. Really important thing to note, cohabitation agreement, because it's not a legally defined term, can include contracts entered into both by apes, but could also refer to contracts entered into by individuals who are not yet common law apes. It could just be contracts for individuals who are living together. Again, it's not defined, so it could cover a broad scope, but when you come into my office and you ask for a cohabitation agreement, it's almost always going to exclusively mean you are about to start living, or you already are living with an individual who you intend to become an adult partner with, or you already have. And as such, there's certain property you might want to protect, or certain support entitlements you may want to avoid. That's my short story on that.
Can I
Perfect.
just
Tracy?
add, can I just add one comment?
Absolutely.
One of the challenges we often have as lawyers when people come to us to ask about agreements and what is the right agreement to get and to have is sometimes the future is not clear. So one of the legal challenges that we face in how these are written, these documents, is often people need and want a cohabitation agreement, but they might get married, which, you know, life happens, it might happen, right? So I wanted to just point out that there has been over the years a debate among lawyers around how to address this. Many would suggest, and the law certainly supports the idea, that you can have a cohabitation agreement that contemplates or considers the idea that you might eventually marry and it would still remain valid and in place, but it has to be clearly stated and it has to be included in the agreement. And so that's something some lawyers have suggested, that you should get a different agreement. So it's been some debate, but there's been decisions of our court which reflect on, as long as the two people who enter into the agreement, that's a cohabitation agreement, contemplate or include a clause that, you know, understands that, you know, if the two people go on to marry, then what will happen, and that it's clearly set out. So it could become a contract that would apply if you go on to marry, but it's very important that that be clear.
Okay, no, that's very helpful to know. Thank you, Tracy. And then straight into the third question, what can you include in a cohabitation or prenuptial agreement? I think you guys touched a little bit on it earlier about property and spousal support, but if you maybe want to expand a little bit on those.
Who goes first?
Oh, Tracy, sorry, you can go ahead and start.
You know, this is when people enter into agreements or contracts, there's some limitations on what you can contract out of. And what that means is that usually contracts and agreements are meant to contain and to set out in a very clear way what people's rights and obligations are. And so often we talk about, you know, limiting division of property, limiting support. But there's certain things that in law we generally do not include, because you're not supposed to contract out of, meaning, you know, the law doesn't generally support the idea that you can not pay child support, for example. So typically anything to do with the parenting of children in the future, or the idea of child support, is something that generally you do not contract out of by just, you know, at your kitchen table, signing an agreement saying, I'm not going to pay child support, or, you know, the kids are going to live with me and only me if our marriage breaks down, or if our relationship breaks down 5 years from now. These things are things that are governed by principles that are sort of above the ability of two people to contract out of typically. So for the most part, agreements, as Matt very clearly said, typically deal with financial rights and obligations related to division of property, assets and debts, and then this issue of spousal support or partner support. However, and I'll shut up and, let Matt add to this, but we always have to remind people with spousal support, which is one of the main reasons people sometimes want to enter into agreements at the beginning of relationships, you can have a clear contract setting out what those entitlements would be and what your mutual agreement is. But under the Divorce Act of Canada, which governs people who legally marry, and even under the Family Law Act, which governs the partner support of people who are not legally married and living together, an agreement is one factor that will be considered if there is a dispute. So I just wanted to say we always have to remind people that it's never 100% secure when you have a contract that says that, say, for example, there will be no spousal support at the end of our relationship. That may be considered, and it may be considered to have a lot of weight if the agreement is a good agreement and found to be a good agreement. And we'll talk about that, I know, in questions coming up, what that means. But it may not be the outcome if there are other factors in play, because the court always has the ability, there's legal considerations that may come into play. With property, if it's a good agreement, usually you're pretty set, it's pretty certain.
I'm assuming you're jumping to me now. Yeah, so what can you include in a cohabitation prenuptial agreement? Almost everything. You could technically include whatever you want to put in there. You could include parenting, child support, and property. Just the courts may not enforce everything you put in there. So if you put child support in your prenup or cohab, you can almost be guaranteed that the court's going to say, yeah, that's not enforceable. If you put parenting in there, court's also likely going to say, no, that's not enforceable. Doesn't mean you can't do it, right? I think the example is I can ride my bike on the freeway. Technically, I can do it. I can get on a bike. Will the police stop me at some point? Absolutely. But I could get my bike on there for sure without someone stopping me. Same thing with parenting and child support. You throw it in the agreement, you can throw it in there. Someone's just going to stop you from relying on it at some point in time. After that, the two areas that are most commonly are spousal or adult independent partner support or property. The legislation in Alberta, the Family Property Act, specifically permits us to contract out of its presumption of equal division for the majority of assets. So property is a for certain, it's a guaranteed, and individuals' rights to contract on those sorts of issues have been confirmed in Supreme Court cases such as Moog. Spousal support, the legislation, as Tracy indicated, doesn't actually give us any tools that specifically says we can contract out of it. Property, the legislation does give us those tools. Spousal support, they don't. So what us lawyers have done is we've created these long books of paragraphs covering every sort of potential scenario, so that if someone were to try and contradict or oppose that agreement later on, we're able to show that this sort of situation was contemplated. But even with that, I tell clients, every 5 years, you should be coming back and discussing this one more time. Because for spousal support especially, life changes in ways that you just can't contemplate. You can't. If we could, I wouldn't be doing this job. I'd be investing on Wall Street. But because you can't, every 5 years come on back, because once you hit 10, 15, 20, 25 years, those spousal support clauses that waive entitlements are almost all unenforceable.
Just a quick comment on that before we go on, Jagat. One of the things that I like to include in agreements prenup or cohab agreements is following on Matt's point, particularly with respect to support, trigger points. So for example, if someone comes to me and says that they want a contract or a prenup or cohab that has no spousal support, what I will typically encourage them to consider is including clauses that say, if there are children, or if after 5 years of marriage, or after 10 years of marriage, or if there are children, that X, Y, or Z will occur, to address the point that Matt just said, because most people want to know if they invest in an agreement that it will be binding. I mean, that's the idea. Why would you do it if you didn't contemplate like having it be enforceable, right? So to be enforceable, you really need to understand those potential obligations that would be more powerful and have more weight than an agreement, such as the support of a vulnerable or a dependent spouse, or in the context of children, which changes the kind of panorama of how the whole thing will be viewed. So.
No, I think it's a really good point that you guys also made about how it's important to keep those updated and come back and check in to like every 5 or 10 years, especially with how often the laws change around this. So I think that's a great point that you both made. And then just moving on to the fourth question. So for cohabitation agreements, when should you make one and what are the benefits? I think we've touched briefly on this, but Tracy,
Yeah.
if you'd like to begin.
Oh dear. Well, just to start the conversation, obviously the ideal scenario is when you are thinking about living, moving in together or cohabiting. That's the ideal scenario, but of course they can be made at any point, and they have benefits at any point because they set a structure in place that have to do with expectations. And one of the things that we as family and divorce lawyers see all the time is the grief that happens, you know, and the difficulties that occur at the breakdown of relationships when there are not clear expectations, and when you have people who driven by a very traumatic experience, a lot of emotion, and so when you don't have that structure in place, sometimes, you know, separations and divorces can be difficult. If you have agreements in place at the front end, when the relations are amicable, when there isn't a heightened level of emotion and distress that is playing out, you know, there's more reasonable agreements, that people are more rational, they're, you know, not in a state of distress. So early on is good. Ideally before you're already in a cohabitation agreement. One of the issues that we were discussing before the webinar started, and I'll pass it back to Matt to comment on this, is, you know, there are a few gaps in the law for people who are needing agreements because they're in some form of relationship with someone else, and they may have assets or obligations that they want to protect, or an agreement they'd like to have. And so this idea of if you are not an APE, as Matt explained, an adult interdependent partner under the law, which is this sort of idea of living together, but you don't fit the definition, but you still want to protect assets, but you're not an APE. And I'll pass it back to Matt because he's recently been thinking about this issue and some of the challenges in terms of when you should make an agreement and how to go about it.
Oh, okay.
Not to put you on the spot, but I was just thinking, like, what if you're not an APE?
Yeah, absolutely. So I actually just wrote an article on this and I stuck it in the chat. So if the hosts want to share it, they're more than welcome to. Essentially, Tracy was absolutely correct. Before you start living with someone, and the way I like to frame it for individuals is before entitlements trigger is when you should be considering and signing cohabitation agreements. That is for adult people who are looking to become adult independent partners. That's before they've been living together for at least 3 years, or before you have a kid with someone while you're living with them. That triggers it immediately. Or before you sign any sort of contracts turning you into adult independent partners, you should be looking at executing these agreements if You do not want to divide your future property 50-50 or create partner support entitlements. Now, Tracy indicated that there is a gap in the legislation right now, and in my opinion, I think it was a mistake by the legislature when they were preparing the law. However, if they don't address it, then that mistake still stays there. And what the gap is that the law gives us a tool to sign prenuptial agreements for individuals who are looking to get married, to actually contract out of the entitlements created for property division. So property division, normally everything acquired while you're married is divided 50-50. Same thing with adult independent partners. Everything acquired while you're living together, most of it, with some exceptions, is divided 50-50. The law allows those married individuals and gives us lawyers the tools to contract those married individuals out of that presumed 50-50 division. But it does not give us the tool to do it for adult independent partners before they become adult independent partners. And the reason why that is a problem, especially for adult independent partners, is that property entitlements actually start from the date you started living together. So if you start living together at this date, 3 years from then, you become adult independent partners. As soon as you're adult independent partners, all that property you acquired in the last 3 years becomes divisible 50-50, most of it. But you're not permitted to contract out of dividing all that property 50-50 until your other partner and you have created entitlements under the law to that 50-50. So the motivation for individuals to execute that contract quickly disappears because they already got entitlement to 50%. Why would they give it away? So there are tools we can use and strategies to still make those contracts enforceable. Unfortunately, because the law is new, they haven't been tested yet. In my opinion, I do believe that even though there is that gap, any sort of contracts entered by individuals in contemplation of becoming adult independent partners are going to be upheld in one way or another. It's just not a guarantee as to how the court's going to decide to do it, or if the legislature is going to step in earlier on to change it. But I'm starting to get into something that's a little bit overly technical for most people. So really all people should take away from this is, yes, you can enter contracts if you're not yet married and you're not looking to get married, to protect your property and to avoid support issues later on.
Can I just add one comment just to, without getting into the technical aspects, a further complication is that in Alberta, there have been several situations where couples have not lived together, but have been found to be adult interdependent partners. So imagine then the stress on all of you in terms of deciding when you need an agreement. So just to throw that out there, if there is a financial interdependence, and I'll just give you like one scenario so you know what I'm talking about. You know, there was an Alberta case where a fellow had a girlfriend in Mexico, and, you know, they holidayed together and he was sort of paying for most of the expenses, but they never lived together. The court found that, in fact, that was an adult interdependent partnership. And so then there were all of the claims for property that would flow from that definition of a relationship, but they never actually lived together. So I just wanted to alert people to this idea that, you know, think earlier than later about agreements if there are concerns around setting out expectations of, you know, sharing of resources and assets and debts and things.
Thank you. And then question 5. So I guess we similarly talked about this, but then I guess it's the same application to prenuptial agreements about you should make them as early as possible.
Well, one of the things that I wanted to say specific to prenuptial agreements, a little bit different than cohabitation agreements, which is really important. What we want to avoid is a situation where someone is being ushered into the office of a lawyer on the day of a wedding. And that happens. I'm not even exaggerating. In fact, I glanced at a few cases before this just to refresh my memory, but I've personally worked on cases where an individual was taken to a lawyer's office on the day of the wedding. One young woman in particular, she was supposed to be getting her hair done, and she was taken to a lawyer's office, told to sign the agreement or the wedding would not happen. And that agreement was found to be valid, much to my horror, but that was before I was involved in the matter. But so in terms of timing, what we want to avoid is we want to avoid a situation where someone is effectively, you know, has a gun to their head. This notion of duress, right? You should enter into these contracts when you don't have someone literally standing over you with a hammer, right? Like you have to sign this or else. And so a good prenuptial agreement is more likely to be binding and enforceable in the future. And what determines good, which we will talk about, is open to interpretation of the law and of the facts of every case. But I will tell you in terms of timing, if you want a prenup, you want to think about it well before the wedding day. Like that's just not a fairness context. And it will be looked or frowned upon by many of us as forcing someone into a very, very sort of unfair set of circumstances.
Perfect. And then Matthew, do you have anything to add also as well to like what the benefits of a prenuptial agreement are?
Well, the slide is when, but the benefits of it, we kind of covered earlier. It's you protect your property and you can prevent support entitlements. I like to use prenups and cohabs to protect the most important property sometimes, because my practice, I deal with a lot of businesses, individuals who are separating, who have businesses or farms. Sometimes when they do come into my office before getting married, sometimes the conversation about protecting all assets is enough of a conversation to completely destroy a relationship. So instead, we'll protect the most important asset, the one that both parties can agree, you know, this isn't something that the other party has contributed to yet. So that's usually the business or anything that's not really worth anything at that time, that there might be value in it later. So the agreement will just focus on one asset rather than all the assets. So that's in terms of some of the benefits there. But when the rule of thumb I tell people is as soon as you're engaged is when you should start thinking about signing that prenup. If you have property to protect or you want to avoid support entitlements. So if you're a high income earner, or you're going to be a high income earner, talking people who are in med school, doctors, professionals, business owners, you want to look at getting that prenup as soon as you get engaged. If you're on the other side, you're going to be the stay-at-home parent, you're not going to work, you don't have any sort of plans to start a business, you want to avoid the prenup. You want to have all your entitlements in check. So there you go.
But in just one quick comment, the other thing around timing is you need to give the partner who has less assets or less money time to process, because a typical scenario would be, and often it's, you know, people with assets who are partnering with sometimes, you know, like the young woman from Brazil, or only because I've seen about 3 or 4 of these cases, someone who doesn't speak English, who is a lot younger, who doesn't have any assets. And so often when they come into my office and we sit down and we go through the proposed agreement, typically there are tears. There's a huge emotional reaction when they realize that what's on paper in this, like, you know, beautiful, loving relationship that they're in, that you're getting nothing. They need time to process that and to then sort of deal with the practicalities of a negotiation at that point. So leaving it to the last minute is never a good idea, because you've got to expect there's going to be a bit of fallout when the true nature of what's being proposed is realized. It's happened so many times, I can't even tell you, that we can't even have a full meeting about what's in the agreement because the person just completely breaks down in tears.
No, thank you. So we do have about 4 more questions in about 25 minutes, so I might just be asking these a little bit. Yeah. So question 6 is, do you need to make a prenuptial agreement if you get married and already have a cohabitation agreement? Matthew, if you would like to start with this one.
Uh, so yeah, the question itself is actually a little bit incorrect. If you are already married, you're not going to enter a prenup. You're going to enter something called a postnup. It's an after marriage agreement. If you have a cohabitation agreement and there's no clause in it that says that this agreement was entered in contemplation of a future marriage, then yes, you need to get a prenup before the marriage, because that agreement, as soon as you get married, may not be enforceable. But if your cohabitation agreement includes both living together and there's language in there saying, also in the event that we get married, this is intended to remain in full force and effect, then you should be fine.
Okay, perfect. Tracy, do you have any additional comments on that?
Sorry, I was just typing an answer to a question. No, I generally support the notion that if you're going to do a cohabitation agreement, it makes more sense to contemplate a possible marriage and write it right in, so that you would never need another agreement if in fact you do get married. But every case is fact specific. So legal advice is important if there are a lot of assets or a lot at stake.
Okay, no, that's helpful to know. And then question 7, what are some common myths and misconceptions of cohabitation and prenuptial agreements? Tracy, if you want to begin with that one.
For this question, my first thought is, first, that the agreements will be always binding, and second, that the agreements are not binding. And I partially sort of am joking about that, but there's a lot of tension in the law around this conflict between pure contract principles, sort of going to heads with notions of fairness and reasonableness in the family context. So I think you just, I don't know if I would call it a myth or a misconception, but what I would say is there's this tension. And so legal advice is always important. You don't have to retain a lawyer and spend a lot of money on a lawyer to get good advice, even just one appointment, to understand how your situation may best be handled in the context of an agreement. But it's definitely misunderstood that all agreements are always going to be binding and that all agreements are not going to be binding. And it just comes down to the specifics of every case.
No, that's helpful.
And also that agreements are expensive. They don't have to be crazy expensive. Most lawyers now can help you do an agreement without breaking the bank. And so don't be fearful of lawyers, because an agreement does not have to be a hugely extensive engagement with a lawyer. We've come up with certain strategies and ways that we can make these things as affordable as possible for the average person.
Thank you. Matthew?
Yeah, the 3 most common myths and misconceptions I see in them. First one is touches similarly to what Tracy said, is that these things are always guaranteed rock solid enforceable. Not true. As Tracy indicated, we have a court of equity in Canada that is essentially a court of fairness. And normally with contracts, the courts don't like to disturb what people have agreed to. But with family law specifically, the courts really feel strongly about fairness. And so even if you contract to something, if it is inequitable, if it's not fair, and it is not fair in the context of the language of the governing law, then the courts might step in and do something, even though you have a fully contemplated and negotiated agreement. The second thing is that parenting is something you can agree upon at the beginning of your relationship. More times than not, I see people come and they say, well, if we ever separate, we're okay that she's going to have primary parenting. And I'm like, I'm not putting that in there. No, it's not enforceable. And they try and they're like, why not? It's in the kid's best interest. And I'm like, the kid's not even born, one. And two, if the kid's born, how do you know what the kid's best interest is going to be in 5-10 years? You don't. So those are the two big ones. I had a third one there, and that is that these agreements have to include everything. They don't. You can enter a cohabitation or prenuptial agreement that's specific to one asset or specific to support from a specific scenario. You don't have to touch everything. So you can avoid a lot of the conflict that comes with, oh, but that cave to me, that asset was a gift to me from my grandfather. You don't have to talk about anything. You can focus on the only thing that both parties agree is a real issue.
Okay,
Can,
perfect.
can I just quickly add one comment? One thing that just really quick, I know I have questions, just to say a fight that always happens because it's a misunderstanding. You could just do a simple short agreement about the parents' down payment on the house, because a lot of people, that is often a source of a lot of grief when separations break down, particularly with younger couples where parents or family have helped with an investment in a home. Just sort that out. That kind of thing. Just following on Matt's good advice on that.
No, thank you. And then question 8 is, what are the legal requirements to make a cohabitation or prenuptial agreement enforceable? I know we just talked about how they aren't always binding. So what does make something binding?
Absolutely. So in order for the property sections to be enforceable, it has to, you have to have signed it in front of a lawyer for the property. For the rest of it, there's no legislation that says it has to technically be signed in front of a lawyer. But if it's not, you're going to have a hard time enforcing it. So legal requirements, the real legal requirement here is for property, it has to be signed in front of a lawyer. Oh my gosh, sorry, thumbs up there. That happens to me all the time. Has to be
Giving himself a thumbs up.
Has to be signed in front of a lawyer. After that, disclosure. So if you want to waive property, you have to tell them what property you want to waive. If you want to waive support, you got to tell them the income that they are waiving support from. Disclosure. So those are the big legal requirements. There's little nittier grittier things in there, but that is an issue for your lawyer, not for you, right? Don't do this at the kitchen table. Go talk to a lawyer and they will get into the nitty gritty with you.
Is there time for me to just throw in a couple of comments here?
Yes, Tracy, go ahead.
So this is the key question, right? There's almost like lawyers who specialize in setting agreements aside, right? It's almost like a little mini industry in the legal profession around how to overturn agreements. And that relates to what the legal requirements are. So there's a lot of debate in the law when people have fought about whether an agreement is valid or enforceable and whether the legal requirements have been met. There have been several cases that have gone through the courts in Alberta and in Canada up to the Supreme Court, including one big decision from the Supreme Court last year on the legal requirements of an agreement. So it's an ever-changing area of law. And while the law may not technically require you to have what's called independent legal advice, where you sat down with a lawyer, not just have it witnessed by a lawyer, but sat down with a lawyer to get advice. And the law may not technically require fulsome financial disclosure before an agreement. The best practice in Alberta and in most of North America to have an agreement that you can rely on is to, in fact, have those things, which is independent legal advice, to have sufficient financial disclosure to know what you're signing away or giving up. And related to one of the questions in the questions, what that disclosure is varies. For a prenup, it might be the big picture, right? In different types of agreements, particularly at the end of relationships, it's a much higher level of disclosure. But there's no question, if you have an agreement where there's no disclosure, there's going to be certainly a question of trying to set that agreement aside if it results in what we call a substantive unfairness, like something that doesn't pass the smell test. Like it just, most people on the street would go, that's not fair. So just saying, there's best practice and there's legal requirements, right? So.
Okay, perfect. And that kind of goes into, I guess, our next question, which is like, in what cases do you not have to follow what the cohabitation or prenuptial agreement says? I know one point that we've talked about is fairness. And then if it comes up in a court of equity, is there any other situations where it may not be enforceable?
Are you looking to me or Tracy?
Oh, sorry, Matthew, you can go ahead first.
Okay. So parenting and child support, those are the two areas I would say most commonly, if you put that in your agreement, it's unlikely to be enforceable. After that, if you did a fulsome agreement with lawyers, you can assume it is enforceable until you had the court set it aside. If you did an agreement at a kitchen table, then it might be enforceable, it might not. You should go talk to a lawyer. This question is a very gray question to answer, in that the question really depends, or the answer really depends on unique facts. So outside of parenting and child support, the rest of it, go talk to a lawyer.
And then the complication there is, for example, if there was what we call a material non-disclosure, that means like something big, like, it wasn't mentioned that there was, $5 million in a bank account, like something big, right? Say that happened. Well, that might impact on certain clauses of division of assets, but it might not have an impact on other parts of an agreement, because often the agreements will have clauses that say if one part of this agreement or one clause becomes unenforceable by matter of law or found to be enforceable, it wouldn't disrupt or make the rest of it unenforceable. So you can see how it can get a little bit tricky in terms of when you do not have to follow. So for the most part, if you enter into an agreement, you're supposed to follow it. And you should follow that sort of general principle, right, of just good faith, like you should follow the agreements that you sign. But there may be parts of an agreement or a whole agreement that is found to be wholly unenforceable or partially unenforceable because of some big issues. And one of them is unconscionability, like we've talked about, huge material non-disclosure, like some sort of gross flaws. But I can tell you right now, having worked on several cases where there are agreements that are highly suspect, they've been found to be enforceable, notwithstanding, that barely passing the smell test. So it really is tricky, and legal advice is a good idea.
Okay, no, thank you. So those are the end of our formal questions. Now we'll open it up to you. So what else would you like to know? Please, if anybody has any questions, they can write it in the question and answer box in Zoom. And please remember that we cannot give out legal advice, only legal information. So
I tried to type in a few answers thinking we'd run out of time.
yeah. So I guess the first one is, I think Tracy had mentioned this earlier, is do you have to disclose the value of your assets to your partner or in the cohab agreement?
It depends on the nature of the asset. I'm going to give a lot of it depends. Best practice, yes, right? We are obligated in family negotiations to disclose our assets and their values. However, if the asset is small, such as if we separate, I'd like to keep the hairbrush given to me from my grandmother. Well, the value isn't going to be a problem there. It's the specific asset of it that is the issue that you need to indicate. But if the asset is $1 million in an investment account, you're going to have to disclose that, one, you have an investment account, and two, that there's $1 million sitting in it. Otherwise, you may not protect it.
Well, thank you. So we do have quite a few. And then another one is, do the investments from property and assets held before cohabitation agreements be divided when you become cohabitants?
So this gets at that question that Matt answered earlier. We have this tricky scenario where you don't become an adult interdependent partner with sort of automatic entitlements to divide property until you've lived together for 3 years, or you have a child, or you agree. And so if you think you may become an adult interdependent partner, you want to put your mind to getting an agreement before the 3-year mark or before there's children. Because at that point, if there are significant assets that have been acquired from the time you've lived together or been determined to be an adult interdependent partner, they could be in the pot for division. Generally, as a matter of law, those assets and debts that you hold before you live together, before you become adult interdependent partners, or before you marry, if you don't live together before marriage, like the before assets, generally those are what we call exemptions, and they're out of the pot. However, it gets complicated, and there could be an increase in value of an exempt asset that could be in the pot. So this is why with property matters, it's always good to get legal advice. And I know that sounds like lawyers just trying to drum up business, but we're all too busy. We don't need the business. It's really just about trying to help people protect their rights and entitlements and just understand the law. And it is tricky with property. And then related to that, to get that independent legal advice, it's not it's available. I'm not saying that it's free. Most family lawyers don't work for free, but through the Edmonton Community Legal Center, through Calgary Legal Guidance, you can sometimes get free consultations with lawyers for fairly affordable rates. Most lawyers will do one-off consultations, like just one appointment to give you, a sense of what may be important for you to know to try to determine how to best protect your entitlements, rights, and obligations.
Okay, perfect. Thank you. And then I guess with that, how you were mentioning that people should look out to get a lawyer, one of the questions was, do people need to hire their own lawyers? Does each party need to hire the individual lawyers?
I just typed out an answer.
Okay.
Yes. Both of you, in order for that cohabitation or prenuptial agreement to be enforceable, will have to hire your own independent lawyers from one another for the most part. So yes.
Although just one way to make it maybe more affordable, often what happens is one person will have the lawyer gather all the information, draft it, write it all up, do some negotiations, and then the second person will find a lawyer to provide independent legal advice in a more contained way. So they're jointly sort of maybe paying one lawyer to do the bulk of the work. So there's ways you can streamline it, but at the end of the day, for a good agreement, it's best for both of you and you really need to have a lawyer on both sides.
Okay, perfect. And then another question is, are your assets yours in value prior to living together and only divisible in value what they gain while you are together?
Yes. Yes. But that's only if you can prove that you had the asset before you started living together, and that what that value was when you started living together, and that the increase in value stems from that asset specifically, right? That increase in value is subject to a potential division. But yes, the value of an asset before you start living together is not usually a divisible asset.
Okay, perfect. Thank you. And then I'll just do one last question because I think that's all we're going to have time for is, can a cohabitation couple do anything to protect themselves with respect to housing when they are both contributing but not contributing equally?
Cohabitation agreement.
Exactly. This is the perfect example of where an agreement would really help you if you wanted to ensure that there was a recognition of different contributions.
So there are strategies that are not cohabitation agreements that some individuals use, but there are strategies that try to reflect that you two are not jointly contributing, and that instead, in the most common situation with regards to a house, is one person owns the house and the other person is a renter, and they pay monthly rent, and they have a rental contract, and it's essentially a different kind of contract that specifically states that we are not living together, as adult limited partners. I am renting a space of the premises from this individual. And I've seen people use that to prevent themselves from being deemed or considered adult independent partners. But that doesn't really create any sort of division of property between the two. That is, one person keeps the property, the other person gets nothing type situation.
And then there's also the complication with sort of implicit in a question like this. What are people's contributions? And in families and in relationships, there's lots of contributions that wouldn't normally necessarily be considered. So it may be that one person is financially paying a mortgage, but the other person is doing all of the domestic labor or caring for children or doing those things that are not always what we call quantified. Numbers are not put on some of those contributions. So a good lawyer would say to someone who's saying, okay, well, my partner only pays 30% of the mortgage and I pay the rest, so I want to protect that. I would likely, as irritating as that might be, say, well, what are the other kinds of contributions that are being made? Maybe it's actually fair. Just say.
No, I think that's a really helpful distinction where the value isn't always a number in terms of when it comes to those domestic additions. So those are all the time we have for the questions. So thank you so much, Tracy and Matthew. I know I learned a lot, and I hope everyone else who joined us did as well. But also on that note, let's stay connected. So you can find CPLEA online and on social media. You can also subscribe to our monthly e-newsletter to get the latest updates in the law and our resources. As well, Matt has put a link to a survey in the chat. So if you could please take 30 seconds to complete this survey and let us know how we did today. And then also, Tracy and Matthew, do you have any closing remarks or comments that you would like to add?
Yeah, one thing. If you still have questions and your questions are about your specific life or the life of a friend of yours in that situation, it's best just to go talk to a lawyer. Sit down, have those questions answered. If you are low income, you could even consider going to ECLC, Edmonton Community Legal Center, and seeking to get a free 30-minute conversation with a lawyer and have some questions about your specific issue answered. But you do have to be low income for that.
And just to say, Matt, you've only done 30 minutes. Most of us volunteer with the Edmonton Community Legal Center, and usually it ends up being an hour, but fair enough, 30 minutes or an hour. But just to say, most private lawyers, like in law firms, most of us charge a flat rate for what's a consultation. And so you can certainly find probably an affordable consultation with a private lawyer if you don't meet the eligibility requirements to be low enough income at ECLC or in Calgary at Calgary Legal Guidance or other community centers. So highly encourage anyone with property in play for one of these agreements to not be afraid of lawyers. For the most part, we're pretty approachable and we're not as scary as some people sort of sometimes think. And it doesn't have to cost an arm and a leg for a consultation. That's, the reality.
Thank you to the both of you. So that does conclude the end of our presentation. And thank you to everyone for joining us, and enjoy the rest of your day.
Thank you for putting this on and for having us.
Take care, everyone.
Take care. Bye.
Bye-bye.